Y'all should be able to see my screen here in just a minute. So just quick introduction. My name is Skip, or my real name is Skipton Reynolds. Sue Mickus and I are the attorneys at Skipton Law. We are a estate planning and elder law firm, and we're going to just talk today a little bit about the estate planning essentials, things that you got to have as a part of any type of estate plan, whether it's simple or complex. So kind of agenda here for the morning is to get to know a little bit about Sue and I briefly. We've got kind of a list of questions that we hear a lot, but maybe we want to hear from you if you've got any questions that are driving you to be here this morning. And then we'll talk about how to, plan and protect your estate as we go through. So kind of our promise is that we will have, the time will go fast. It will be an hour from now, real quick. You will hopefully learn something you didn't know before. And that we'll have a little bit of fun talking about death and dying and incompetency here this morning. And then your promise in return for our promises is that you ask questions, because we want to answer those questions as they come up for you. So a little bit about me. I grew up in the Denver area. I was born and raised in Aurora. I went to Smoky Hill High School, went away to the University of Kansas for my undergraduate. I went there to swim. And then I got my law degree and my master's in business administration from the University of Wyoming. But I do like to briefly say, why I feel like I do what we do in our office. And it's a family experience. I watched in graduate school, my grandmother had dementia, and I watched how my family wasn't prepared for all the things that came along with that. And all of a sudden, everything was in crisis, and we lost a little bit of control over a whole number of things, including where my grandmother ended up going to the nursing home. And it was because they didn't know what they didn't know. And so I feel like I'm passionate, and maybe my grandmother has pulled me into this area to try to help families have a better experience, so that they know ahead of time what they need to have in place, or they're thinking 3, 6, 12 months ahead, so that they have a better result than maybe my family had. Because in my opinion, it's all about family, what we do in our office. It's about allowing our family to help us if we can't do so during life, but also how do we take care of them when we're gone. So I'm going to turn it over to Sue, and she's going to give a little bit about herself. Oh, you're on mute.
Sorry about that. Yes, I'm Sue Mickus. I'm the second attorney in the law firm, and I joined the firm in 2019. Also have ties to the Midwest. I was born in Omaha, Nebraska, spent middle school and high school in Minnesota, finished high school and went to college in Iowa State, and then moved out here after college and attended University of Denver Law. And, got into this practice sort of after doing some other things, some commercial real estate and that kind of thing. Got into this practice when I joined Skipton Law, and it has a special connection for me because my family also has experienced a lot of what you're going to hear about today, the crises that are involved with pre-planning and addressing crisis and planning for crisis and that kind of thing. But my mom was diagnosed with stage 4 colon cancer in 2012. She battled for 3 years. We went through the chemotherapy, the in-home care, hospice, pre-planning, funerals and that kind of thing. Lost her in 2015. And then we've also been, since then, my dad has had his own health scare, battling leukemia and making it through a stem cell transplant. He's now 6 years post stem cell transplant. So that's success with that kind of diagnosis. And he also has gotten remarried. So we now have a blended family and have to look at planning in that context as well with a blended family. So that's a little bit about me and how I ended up at Skipton Law practicing estate planning and elder law. And let's see, I think, Skip, do you want to share?
I'll just move it.
Okay, that's perfect. Okay. So again, goals of the workshop today. A lot of these things you might have heard about before, powers of attorney and wills and trust. If you have, that's great. Hopefully we can add a little bit, make you feel a bit more confident, and more importantly, give you some comfort to figure out whether you're all set, or whether there might be pieces that you need to kind of update in your plan and make sure you've got all the pieces in place for your purpose. The main reason we do this is to make sure that you are protected both during life and once you pass, that your wishes are protected, which also helps protect your family. And we're gonna teach you a little bit of the law. It's not going to be a lot. It's going to be more contextual and telling you kind of on an everyday kind of basis what's going to be helpful and help you take care of yourself and your family. And you can kind of listen for the stories that we tell, and hopefully you can remember the stories such that if you need to then communicate back, this is what I need, this is what I want, you can think about the stories that you might hear to help communicate the things that you need and figure out what's missing from your planning. So the way we look at estate planning is that there's two main components to it. There are pieces that address planning for life, so events during life, and then pieces that address what happens after you pass away. So the living pieces, what we call the living documents, or the living pieces of an estate plan, include the powers of attorney, both financial and medical powers of attorney, a HIPAA authorization, and a living will. And I'll kind of go through those briefly one by one. The financial power of attorney is there and put in place so that if you become incapacitated, you have a stroke or advance in dementia or that kind of thing where you can no longer manage your affairs for yourself, the financial power of attorney names someone that you would like to make financial and legal decisions for you if you can't. In contrast, the medical power of attorney is something that helps you if you cannot make decisions on your behalf, if you become incapacitated. It allows you to nominate a medical decision maker for you, someone that can make healthcare decisions, residential care decisions, those kinds of things, and even end of life decisions for you. And the good thing about these powers of attorney is you're choosing who these decision makers are going to be for you. And we even ask in both the financial and medical power of attorney context that you look at alternates. What happens if the person that you've nominated cannot serve in that capacity? Maybe they've predeceased you, or maybe they are also incapacitated. So we look at, in financial and medical powers of attorney, looking at who you want to name as a backup, or even potentially a second backup, so that your wishes and your preferences are documented in case you need those decision makers down the road. The HIPAA release is there to help identify a short list of people that you feel comfortable sharing medical information with. So the medical power of attorney is the decision maker. Then the HIPAA release says, okay, in addition to my medical power of attorney, I am comfortable and I would like the following people to be able to speak to my doctors. So say, for example, someone lives out of state and they want to call the hospital and get an update on status, or when you might be going home. If that person, say it's a child that maybe lives out of state, is listed on your HIPAA release, then the medical facility can speak to them. We like this particular HIPAA release. You see HIPAA releases a lot in doctors' offices. They ask you to sign them frequently, almost every time you go in. But the nice thing about this HIPAA release is it applies to any and all of your healthcare providers. So when you go into the hospital or you go into the doctor, if you're doing it on a case-by-case basis, that HIPAA authorization pertains to that provider, just that provider. It also assumes that you have the ability to sign the document when you come in. So this separate HIPAA authorization or HIPAA release that we include in estate planning allows for you to do that pre-planning, to think ahead, such that you are signing this document, naming these people while you're clear and healthy and, can do that. And then it also is there in place to apply to any of your providers and not just that specific facility. And then the last piece that we're looking at as part of the living documents is the living will, frequently referred to as advance directive. And the living will is there as documenting or communicating your wishes to your medical power of attorney. So your wishes to your medical decision maker about how you feel in the case of life support and the need for life support, or potentially organ donation. So that's how that differs from the medical power. It is your wishes with respect of end of life, life support, that kind of thing, that you're communicating to your medical decision maker as well as your broader family. It helps them all understand how you feel and makes your wishes clear with respect to those topics. Trusts have a little bit to do with trust assets during life. Skip's going to talk a little bit more about that later. But if you do have assets in a trust, then the trustee or a successor trustee can help manage assets if you become incapacitated during life. Skip, you can go up
Okay.
for the, okay. All right, so we've talked kind of a little bit about the different kinds of living documents, the documents that help you during life. And I want you to kind of think about the word documents versus each of these pieces really being part of a broader plan for you and not just a document. So these pieces are intended to be more than just a document that names somebody. It is intended to really truly communicate your wishes in the event that you can't. So we want to make sure that they are doing what you want them to do when they're needed. So for example, if you think about a blank check can be used to potentially access all of the assets in a bank account. That's pretty broad authority, pretty broad access, pretty broad power. If you sign a financial power of attorney, you are potentially signing a super blank check. That power of attorney can be looked at as a super blank check because it can give access to more than just a bank account. It can give access to your investment accounts, your retirement accounts, your stocks, your insurance policies, that kind of thing. So you have to stop and really look hard and think about who you're naming, who you've got in as backups. We want to make sure that it's very powerful because we don't know exactly when you're going to need it, but you need to balance that with who you've got named, that it's somebody that you trust, that you feel like will serve well in that role, that they'll be comfortable and competent to carry out those wishes for you financially and legally. So you've got to stop and look at it and make sure that this document has the full authority that you want, because we don't know when it's going to be used. So we want to be broad such that it can help you when necessary. And then we want to be very specific about those broad powers that you give. And I'm going to give you an example. Common in Colorado, a financial power of attorney will give an agent the ability to help someone with their real estate transactions. And it just says real estate, anything to do with real estate. But if you build in further instruction with that authority and say things like the ability to sell or purchase or finance or lease or improve, that is further instruction to your financial decision maker about how you think and feel regarding these powers that you're given. So as we're putting together financial powers of attorney, we want to make sure that full authority is given, so broad power, so that agent can actually help you. But we want to make sure that they're nice and specific, giving good instruction so that agent then knows how to proceed. So a document is just going to name the person. This is my financial power of attorney. But really thinking of it in terms of a plan is making sure that it's granting full authority with good instructions. A common example where we find people run into trouble is, for example, the ability for an agent to execute trust documents for you. Someone may be concerned and not know exactly what that means when they're signing a financial power of attorney, and so they don't give that power. But we have had to go get conservatorships for clients because their power of attorney hasn't given their agent the ability to sign a trust document. Trust documents can become super important in things like Medicaid planning. In applying for Medicaid, there can be cases where a trust document is necessary to satisfy Medicaid's requirements to qualify for their benefit. So that's an example where a power of attorney, kind of a standard document type power of attorney, doesn't give the full authority that we need. Moving on to the medical power of attorney, how do we take that medical power or healthcare power of attorney from just a document that names the decision maker to really part of your plan? Is we build in things, we include the HIPAA authorization that applies to all of your providers and not just one. We tie a living will with it so that we're giving that medical power of attorney some instruction about how you feel with respect to end of life issues. That medical power of attorney is, we kind of look at it as a God proxy, because this person ultimately is the person that decides whether you get put on life support or not, meaning whether you might continue to live or when it's time to go. We look at this as not necessarily a yes or no. Yes, I want life support, or no, I don't want life support, because we can build in things like, yes, it's okay to put me on life support, but just for a period of days, like 3 days or 5 days. We call that, once someone is put on life support, with that ability to revisit within a few days, a second crack at the apple. That gives your medical power of attorney some flexibility. It allows you to do what's instinctual and put you on life support, but you've got a voice out there that says, hey, listen, this is really not something I'm interested in long term. So that, please look at this as a second opportunity to revisit the issue if I've said it's okay, but only for a certain period of time. So that living will is part of that plan, that medical planning, that HIPAA authorization as part of that plan, where you're saying, hey, this particular son, my son Jim, is the medical power of attorney, but I also want my son Scott and my daughter Mary to also have access to my doctors to ask questions, get status updates. And so that HIPAA authorization can add to the planning and wishes, which makes more complete and full care for you the way you would like it. And then finally, the other piece that we can add with the medical planning for life is potentially a personal care plan. That is something that we can add to an estate plan where you're communicating to your decision makers and your family things about how you would like your day-to-day life to look when you reach sort of end of life. You might be in a nursing home or on hospice. It's things like, I would like visitors, but I'd like visitors limited to early in the day. I would like to continue to, attend some sort of religious service. Please, this is a place for you to put that down, put your wishes down in writing. If you like a glass of wine with dinner every night, you can express a preference. Hey, listen, if I'm in nursing care, if I'm in hospice, will you please continue to try and, let me have that glass of wine with dinner every night? If those kinds of wishes are important to you, we can also wrap those in. Skip's going to talk a little bit more about the end of life planning, but just on a basic level, a last will and testament is part of an estate plan, and it accomplishes the main two things of, number one, identifying who you would like to manage your assets when you pass. So who's going to administer your estate? But then it also identifies who you would like to receive your assets, to get your stuff when you pass away. So those are the two main pieces, the sort of main intentions behind a last will is, who do you want to administer and who do you want to give your stuff? One short little comment or two about what happens if you don't have these things. If you don't have powers of attorney in place, the law basically says that you need to have decision makers, even if you don't have a power of attorney. So what the law says is, if you don't have the powers of attorney in place, then your loved one, someone who's trying to care for you, may have to go to court and ask for those authorities, ask for that power. That comes in the form of a conservatorship or a legal guardianship. So if you don't have a financial power of attorney and you're unable to make financial and legal decisions for yourself, someone is put in the position of having to ask the court to appoint a conservator for you. On the flip side, if you don't have a medical power of attorney in place and you need someone to make medical decisions for you, then whoever's trying to arrange care for you is looking at going to a court and petitioning or asking that a guardian be appointed. So a conservator is like a court-appointed financial power of attorney in Colorado, and a guardian is like having a court-appointed medical power of attorney. And then the last piece, what happens if you don't have a last will and testament when you pass away? Well, there's also laws in place that say, okay, we need to know who's going to administer your estate, even if you don't have a will. And we need to know who's going to get your stuff, even if you don't have a will. So essentially, if you die without that last will and testament, we look to the law that says basically who has priority to administer your estate. So state statute will define who administers your estate, and state statute will define who gets your stuff, meaning who are your heirs. And it goes through essentially a family tree, looking at spouse, biological children, if you don't have that will. And then it even goes so far as to say, okay, if you don't have a spouse, you don't have a biological children, then who inherits? And it basically goes up your family tree to your parents, and then down your family tree to your siblings and nieces and nephews. So those are some of the consequences of potentially not having these pieces of an estate plan in place. As planning is that you can have essentially the law make these decisions for you. All right, Skip, I think you're up now.
Yep. Thanks, Sue. So who can come after your stuff? So Sue just talked a little bit about the government, and how you can have the guardianship, the conservatorship, and even the probate after death. We'll talk a little bit more about some other government stuff coming up, but also there's long-term care costs. There's our family members could actually be predators. And of course, no one ever sues anybody in the United States, right? Don't we wish? So let's talk about, oops, went the wrong way. Government. So guardianship. Now, if it's for a minor, you don't get to choose who's going to be guardian over them. But we talk more in the terms in our office of adults. You don't get to pick who these people are. Like, you might have two kids and they could potentially fight over who's in control of taking care of you, but also in the probate sense, after you're gone, who's taking care of your estate, who's more trustworthy in their eyes, or whatever it might be. But one of the things that a lot of people ask questions regarding the government is related to taxes, and how do I avoid as many taxes as I can? So I'm going to start with kind of the good news, and then I'm going to get to the bad news. So the good news is that each one of us has what I call an estate exclusion amount, or a coupon, meaning how much can we die with this year and not owe anything in the form of what is called an estate tax. Some people call it a death tax. And that number this year is 12.9 million for each one of us. And it is slowly adjusting upward. Last year, it was a little bit over 12 million. This year, it's almost 13 million. I'm sure next year it will be over 13 million. Big question mark is we don't know what's going to happen come 2026. The current tax bill is slated to expire on December 31st of 2025. And we're not sure what's going to happen after that. Will it stay high as it is now? Will it go back to a previous number, which is about 5.5 million from 2017? So we'll see where that ends up going. We all live in Colorado. Colorado is a great state to live. As funny as this may sound, it's a great state to die, because we have no state estate tax. So even if you had $100 million estate, you might owe something to the federal government in the form of a state tax, but you owe nothing to the state of Colorado for that same large estate. We can also now give away, and many people remember this number being different, but we can now give to whomever we want up to $17,000 annually without having to tell the government that we gave that money to whomever we gave it to. And it doesn't mean that you can only give it $17,000 one time. You can give it, if you got 3 kids, you can give 17 to each of your 3 kids. And if you're married, you can actually stack that together and you can each give 17. So in theory, you could give each of your kids $34,000 without telling the government that you've given it to them. But the question that we hear a lot when it comes to that kind of gifting is, well, do they owe taxes? And the great attorney answer is, well, it depends. And it really depends on what did you give them. If you gave them what I'll call cash, which could be, in the form of a check or real cash or whatever it is, that does not have any taxation, because any tax that was taxed came to you who gave it away, because it was interest in that CD or whatever it might be. If you take it out of your retirement account, like your 401k or your IRA, you're going to owe the taxes, income taxes, before you give it away. They're going to just receive it as is. But if you give away things like a stock, or you give away things like your real estate, there could be a capital gain tax at a later time when that stock or that real estate is sold. Technically, it goes back to whatever you bought it for. So if my parents were to give me Amazon stock that they bought at $5 a share, and I go and sell it later at $100 a share, I'm going to owe $95 potentially per share. Same kind of thing with the house. A lot of people give away their house, and it can be problematic from the perspective of, well, I gave away my house because I wanted to achieve a result of, say, avoiding probate with it. But I didn't understand that when my kids go to sell it, but I've lived here for 20 years, that there's going to be a tax in the form of capital gain tax that will be owed, which will actually lessen the amount of money that you actually transferred. So you kind of got to be careful in what you're giving away. But there's also this thing called a lifetime gift exclusion. And what they did way back in 2011 is they matched what you can die with what you can give away during life above the annual gift exclusion, that's $17,000. And so this year it is $12.9 million that you could give away during your lifetime and owe zero in the form of gift taxes. Now, like I just described, there may be other taxes, but in the form of gift taxes, there would be a zero. So most people, many of us don't have 12.9 million. Oh, by the way, if you're married, you can double that number, making it over 25 million. Many of us in theory, could give away our entire estate and would owe no gift taxes. Now, please don't rush out and give big pieces of your estate away. That's not what I'm saying. I'm just saying that it can happen. But here's kind of how it works to understand it. So let's just pretend that my parents wanted to give me $100,000 for renovations to our office. So the first 34 would come off the top, 17 from mom, 17 from dad. The remaining, what is that, 166? They would need to file a federal gift tax form. And all the government wants to do is track it. They want to subtract 166,000 from the 12.9 million you can die with, and 166,000 from the 12.9 million you can give away during life. They just want to make sure you don't die or give away during life anything more than the allowable amount. So again, for many of us, if we don't have those large estates, it really probably is not a big deal. But a lot of people don't understand that rule and would like to help a kid out or a grandkid or whatever. And they're concerned if they give more than that 17,000, somehow it's going to create a big tax issue for them. What I'm telling you is that obviously you got to talk to your accountant, but that for many of us is not a huge predator. Where I do see a big predator is many of us, if not most of us, have saved the vast majority of our retirement savings into a retirement account, such as an IRA or 401k. And that money, if it's not in the form of a Roth, generally speaking, has never been taxed. And so every time we take money out of it, we pay income taxes on it, right? And then once you reach a certain age, in your 70s, you now have to start taking out what they call required minimum distributions. So the government tells you how much you have to take out based upon an equation and how much you have in your account. That is all taxable to you. When you die, your beneficiaries owe income tax on that money as well. And part of the Secure Act that came around in beginning of 2020, it changed the game completely, because now your heirs, whoever they might be, children or not, unless they're disabled or a minor child of yours, not a grandchild, but a child of yours, generally they're going to have to pay tax on whatever they receive over the following 10 years after your death. So if my parents leave me $200,000 in the form of a retirement account, I'm going to be taking out all that 200,000 and being taxed at my income tax bracket at maximum over the next 10 years. So in theory, if I were to parse it out 10% a year, take $20,000, assuming no growth, I'm adding that 20,000 to my income taxes every single year for those next 10 years and paying at whatever income tax bracket I'm at. So the tax man cometh. He's coming for you while you're taking it, or he's coming for your family or whomever you're leaving it to when you're gone. So many of us, I recommend talking with your tax person or your financial advisor, if you have one, about what can you be doing to try to minimize the amount of taxes paid by either you or by your family, and what are the best techniques to do so. Because in my opinion, since most of us aren't going to have over, say, that 12.9 million, but most of us are going to have retirement accounts, this is the estate tax. It's coming in the form of income taxes to your beneficiaries at whatever their rates are. And if they're in a higher rate than you, maybe you should have paid the tax. Just saying. So talk with your tax people about that, but that is a huge predator that we see a lot in our office. It's generally, if not the largest asset folks have, the second largest behind their house. Long-term care costs, let me get to that slide, are ever increasing, right? If you want to stay at home and you want to have somebody come in and cook, clean, and be your friend, you're paying anywhere between $25 and $45 per hour. And so, that $30,000 a month is not out of the realm if you have 24-hour care. And this is even non-medical, right? They're not necessarily providing medical services. They may just be helping you shower or get dressed or do the laundry kind of stuff. If you're looking at independent living, $2,500 is a low number. More normal would be probably $3,500 to $4,000. If you're looking at an assisted living, low end $3,500, more normal is probably $5,000 to $5,500. If you're looking at memory care, you're looking at probably $7,000 plus. And if you're going to the nursing home in the Denver metro area, general cost is somewhere between $9,000 and $11,000 now. How are we going to pay for that? Those are big, big numbers, right? And so you got to be thinking about this as a huge potential predator, your estate. Family. So many of us don't think of our family as potential predators, but they absolutely can be. So one of the scenarios that we see quite a bit is remarriage. So kind of like Sue's story, one spouse dies and the surviving spouse meets somebody new and decides to remarry them. Or even if they don't, they now can share, in theory, the entire estate. So like I like to call these people Biff and Bambi, right? So I die, my wife meets Biff the pool boy because she's been dying to put in a pool the whole time, but I've been telling her no. Well, now I'm out of the picture. She's got full control of all of our assets because I left it all to her. She puts in the pool and she meets Biff the pool boy, and Biff takes care of the pool and also takes care of my wife. And now she can do whatever she wants with Biff with all of our money. And you saw in the picture earlier, I've got 2 children. Where are my kids in that scenario if she dies and leaves it all to Biff, or she blows it all with Biff? I have no say on how any of that stuff plays out in making sure that she's protected from, maybe Biff is unscrupulous, right? How can I better protect her from those kinds of things? But then what if she never meets Biff? What if she never puts in the pool? Well, what if after I've died, she needs long-term care, right? So she has a stroke or she's diagnosed with a debilitating disease like a dementia or a Parkinson's, right? Well, that's going to cost money. And all the money that I left her, because she now has all of our estate, can potentially be spent on that. And we can, with planning, protect from these kinds of things. So instead of I like to joke that my estate's worth $2, right? So I have $1, My wife has a dollar. So we've got two together. If I die and I leave my dollar not directly to her, but I leave it through my estate plan, through a will or a trust, I can now allow her to have access to it. But if she meets Biff the pool boy, or if she has that long-term care need after I'm gone, that money can be more well protected from those predators because technically she doesn't own it. The trust set up by my will or by my trust owns it for her benefit. That is asset protection after death that we can protect from the Biff and Bambi scenario. We can protect from spousal long-term care needs after we've died. But then there's the next layer, our kids or our other beneficiaries if we don't have kids. And they're always good with money, right? Or maybe not, right? What if they're a spendthrift? What if they're going through a bankruptcy or go through a bankruptcy? What if they have addictive behavior? What if they are disabled or become disabled, right? They could be perfectly fine the day that we pass away, but the next day have a bad car accident and now they're disabled, right? Or what if we leave them all of our money and then they go and they put it, I call this the condo story. They buy a condo in the mountains and they put their spouse's name on it. Okay, so pretend that's me. I put my wife's name on the condo in the mountains and then she meets Skip the ski bum. Okay, well, now what happens to that property in that divorce? And I would say that she would probably get half. All right. We live in Colorado. We don't have to put her name on it. I can just buy it in my name. Well, do you think she knows that we have it? Do you think she knows that we short-term rental it? And the answer is absolutely she would. And there's case law that backs this up, that she's likely going to get more of our marital estate if she doesn't get any of that in that scenario. Or what if instead of us getting divorced, what if I just died, right? If your kids are married, who are they typically going to leave their stuff to? Oh yeah, their spouse, to go find your kid 2.0 with your money. And if you have grandkids, you have zero say whether any of that money is ever used in any fashion for those grandkids in that kind of a scenario. And in addition to that, a lot of times, depending on when we started our family or our kids did, about the time we get around to dying is about the time that the grandkids are going to school. And if they leave us money, our parents leave us money, and our kids are going to school, they may get less in the form of grants and scholarships and student financial aid that they would have otherwise been potentially eligible for, because now our balance sheet looks bigger. And we actually had a client that it cost her $100,000 for her mom to have inherited a bunch of land up near Telluride right as she was applying for college. Now her parents were land rich on paper, not any, they were still cash poor, but land rich, and it precluded her from getting some of the benefits she might have otherwise been eligible for. So what if we don't like those things for our kids, or we want to try to protect from these things? Well, again, through our will or through our trust, we can bring and create what I'll call the Skip Trust. So my parents can create the Skip Trust. And instead of buying that condo in the mountains in my name, or in my name and my wife's name, we just buy it with the Skip Trust. Now I don't own it. Now, if I have spendthrift issues or bankruptcy issues or addiction issues or become disabled or get divorced or die or the financial aid for grandkids, I don't own those assets. They're at arm's length from me, right? And so because of that, they're more well protected. But if I needed to use it, we could go use the condo. Or what if it's just cash? Well, I can take $10,000 out and take my family to Disney World or wherever we want to go. It's not off limits. It's just in a different form. Again, this is asset protection after death. Now, do you need to do this stuff for your kids or for your spouse? The short answer is, I don't know, right? It really is a personal question. And when we meet with clients, we ask them how they feel about Biff and Bambi. We've asked them how they feel about the condo story as to whether this is an important piece of planning for them or not. And it's a very personal answer. One couple may say, oh, I'm really worried about Biff. Next couple says, yeah, not worried at all. And that's perfectly fine. Our job is as counselors to ask you the questions. Your job is to answer them. And then there's lawsuits, right? So if I'm driving down the road with my wife and she's driving, no, she's not here, so I'll make fun of her. She's a bad driver and she wrecks and I die. Now she's got all the assets, but it was her fault. and the other person died or was injured, now they could potentially be going after our estate. And guess what? She's got the entire estate for them to go after. Or after we die and we leave it to our beneficiaries, if they get sued, it's now subject to that risk because it's in their names. So again, through a will, through a trust, we can create these trusts or these boxes that can more well protect from these types of things. Again, if you want, right? So we protect from these things, but how do we do it? Well, we do it with the right type of trust, right? There's what we call a testamentary trust. It's a trust created by your last will and testament that has been taken through probate that says we are going to create the Skip trust through my will. Or you can go and create living trusts. And there are different types of living trusts. There's what we call a revocable living trust. A revocable living trust is the most common trust that is used out there by estate planning attorneys, or RLT for short. But there's also irrevocable living trusts, things that are created while we're living. But let's talk about what these are and what's the difference between them. So a revocable living trust is kind of like that red wagon you see in the corner of the screen there, because there's 3 parts to any type of trust. The 3 parts are, number 1, who formed it? Who created it? Typically in a revocable living trust or any trust, it would be you, the potential client. The second is who is the trustee? And the trustee is who's pulling that wagon. So the grantor created the wagon. The trustee is who's in control and pulling the handle of the wagon of what's going on with any assets in that trust. And then the third party is who is the beneficiary, or who are the beneficiaries. And in a revocable living trust, typically that would be you, right? So you've created the wagon, you're the one pulling the handle of the wagon, and you get to reach in the wagon and do whatever you want with anything that is sitting in the wagon. It is yours. So my analogy, one of my analogies is it's like taking your money out of your right pocket and moving it to your left. You're still able to use it however you see fit. You're just taking it out with your left hand instead of your right. But a common misconception. Does somebody have a question? No, okay. But a common misconception is that if I have a revocable trust, my assets are protected while I'm alive from my bad guys. And the short answer is that is not true. Because using the wagon example, if I hit a bump in the road in my open wagon, what happens to the stuff inside of it? And the answer is it can fall out, right? It is not protected. Where a revocable trust starts to protect your assets is after you've passed away, to protect from the Biff and the Bambi type scenarios, to protect for our kids, right? It's not protecting while we're alive. It's more of an aggregator. It's a vehicle to transfer more easily. It is not a protection vehicle while we are alive. If you want to try to protect during your life, you have to be willing to give up something. And so typically most attorneys, if they're going to try to protect, will use this one that says IRR tax, or irrevocable tax type of trust. And going back to the 3 parts of this. So you're the one who forms it. You are not the trustee, meaning you're not the one pulling the handle and have no control. And you have to give up 100% access to that money. Because if you have access, like in the revocable trust, it's exposed to risks. So most people, though, in my experience, aren't willing to give up that control piece at a minimum if they're willing to give up access. So we use in our office something kind of halfway in between. And we use this a lot to try to protect at least some portion of the estate from things like those expensive long-term care costs that you saw a few slides ago. And so there's one with the lid, one with the spigot, and one with the screen. And the one that we use the most is the one with the spigot. So going to the 3 parties here, you are the one who creates the trust. But in this one, like the revocable trust, you can be the trustee, meaning you're still in control. Meaning if I put an asset in there, like a house, which is a typical asset that goes in, you can still sell the house and go buy another house, or sell the house and turn it into cash or investments, whatever you want. You still get to make all of those calls. But again, you do have to give up that direct access. But with this spigot trust, the access is indirect. So you can't be the beneficiary of it, but I didn't tell you who you could give it to. And the answer is you can give it to whomever you want, except for yourself or your spouse if you're married. But you usually make your kids the beneficiaries here. So we call this a FIT, or a family irrevocable trust. So you're in control, but if or when you ever needed something out of here, you can get it back out. You just have to do it through your kids. So if my parents had a trust like this and they wanted to buy a new car with money inside that trust, they would write me a check. I'd go deposit it in my bank account, go with them down to the car dealer, and we would buy their car. Indirect access. But what it does is it starts a window of protection that in the event you needed that expensive long-term care, it may be off your balance sheet completely. Now, one quick aside here. We never ever use this vehicle and put everything that somebody owns in it. Number one, I don't want you to have to ask your kids every time you want to go out to eat for an anniversary or something, right? They don't want that and you don't want that. But there's certain things that can't go in, such as our retirement accounts. So those IRAs, they can't go in unless you've paid the tax on it. Your incomes, whatever the source might be, whether it's pensions or Social Security or work, we're not putting that in there because we want you to have that money. We're putting in there only those pieces that you don't want to necessarily have direct access to very easily and want to try to protect. And so we're kind of picking and choosing, and the low-hanging fruit for many clients is their real estate. So this is how we're protecting from things during life and or after death, but you do not have to give up control to start protecting. So you've created this rule book, right? So you created the trust that says, I'm protecting from Biff or Bambi, or the condo story for your kids, or I'm trying to protect during life. So that's your rule book, right? But that's only kind of step one of a 3-step plan of having a comprehensive estate plan. So number one is you create the will or the trust. Part two is you got to take your assets, and using my wagon example, you got to make sure that they get to the wagon. And then you got to maintain the plan and the integration of your assets over the remainder of your life. And if you don't do all three, your plan will fail to work exactly the way you wanted. And we see that quite often in our office, is that people have done plans, it's been many years, and everything's out of sorts. So you create this plan and you now have to integrate it. Because if I'm worried about Biff and Bambi and I have a joint account, or I own something jointly with my wife and I die, she owns it, not subject to my estate plan because of the way it went to her, right? It avoided probate, but it's not integrated to protect from Biff. Or if I name her as a beneficiary on my retirement account or my life insurance or my bank accounts, all avoids probate, but it goes directly to her. If I want the protections of my plan, if I have those in there, I've got to make my assets get to the plan at some point. You must integrate it. And it's one of the number one problems that we see with estate plans is people change assets over time, right? They buy new houses, they change banks, they change employers, they buy new investment accounts, whatever it might be. And they're not watching it, and it's not their fault. They're just not knowing that they have to integrate it, because I think many people think that somehow the plan jumps up in the middle of all of this and grabs it. And if you have beneficiaries or joint ownership, if it's not going to the will or it's not going to the trust, your will or trust is not going to be able to manage that asset, most likely. You must integrate it. And here's how you can set up different beneficiary designations, right? So if you got joint ownership and you're a spouse, it will go directly to them, or any of your solely owned accounts, like your retirement accounts or life insurance or bank or whatever. You can name your spouse as the beneficiary. And you can even go and name the kids as what we call the secondary or contingent beneficiary. And in Colorado, you can actually even do that with your real estate, with what's called a transfer on death or a beneficiary deed. All of this can avoid probate, but it's what we call in our office the here you go plan, because that's really what you've done, right? One of us dies, here you go to your spouse. The second of us dies, here we go to the kids. But if you're concerned about the Biffs or the Bambis or the condo story for your kids or any of those things, the here you go plan falls short real quick. If you want those protections, you've got to take your assets through your will or through your trust if you have one. The big differences between a will and a trust is, in order to create protections out of a will, we must probate it. But if we do our due diligence while we're alive, we can skip those steps and avoid probate with our trust. So analogies I like to use is a school analogy from back in math class, where your math teacher would say, show your work. The will is to show your work. The trust is I know the answer. But ultimately, we can get to the exact same answer. It's just the process of getting there that's so different. But the will is less work for you, more work for whoever's picking it up when you're gone. The trust is a little bit more work for you, but less work for your family when you're gone. So it kind of depends on how you're wanting to set things up, but it is so, so important to set up your beneficiary designations appropriately. Because if you miss this piece, this integration piece, your plan will not work out the way you want. All right, so the goals of the workshop were to identify if your current plan, if you have one, meets all of your goals. We taught through some of the stories, and we talked about how to get what's missing. But before I go on, did we keep our promises? Did our time go fast? By my estimation, it's 11:24, so we're still a few minutes early. Did you learn something? One of the things, if you remember Paul Harvey, he used to say, and that's the rest of the story. And so hopefully you learned something you didn't know before the rest of the story. And then, stupid stories like Biff and Bambi and some of the other things that we talk about, hopefully it would made it a little bit more fun with maybe not the most fun topic area. So if you would like, we do offer to anyone who attends our workshops what we call a free or a complimentary vision meeting, where we're going to assess what are your needs. We're going to ask you about Biffs and Bambis and condo stories kind of thing. We're going to look at your current plan and create anything that's missing if there is something missing, and then try to tie everything together and integrate it. And you can call or you can email requesting that, and I'll have our information up here in just a moment. At that meeting, if you requested it, please bring with you your current estate documents if you have any, because we need to take a look at that and say, okay, this is what you have versus this is what you want and or need based upon what you said was important to you, so that we can talk about the options and creating whatever is missing for you. So I want to thank you guys for your time. Are there any questions? What questions do you have? Sue and I would be happy to answer your questions. And like I said, our contact information is here if you wanted to reach out and set up that free consultation.
Yep, we can just leave that for a moment.
Sure. Was it helpful for you, Vincent? And how about for you, Brian, and your wife there?
For me, it was very helpful. Realize I got to protect myself from the Biffs.
Well,
it was very helpful.
Yeah, maybe your wife wants to protect from Bambi the barmaid when you go drown your sorrows if she passes first, right?
Yep. I know it's going to be a lot of sorrow.
Right.
You might need a trust. Make it easy, but
Do you guys have any questions? We're here to answer your questions as long as you'd like.
why do people go to probate? Is that automatic? You didn't have it with your mother.
It's a great question. So sometimes probate is required and sometimes it's not. Usually if, there's a married couple after the first, there isn't typically probate because the assets are held jointly with the spouse. But frequently a probate can come up at the death of the second. So there's two triggers to probate in Colorado. First trigger to probate is passing away with either real estate or assets that exceed $80,000 collectively. If you have an estate that has either of those things, and you're not married, holding assets jointly, it's just a person dies with assets with their name on it that's either real estate or collectively exceed 80,000, then an estate has to go through the Colorado probate process. So some estates do go through probate, some don't. It just depends on whether probate's triggered by those conditions.
Yeah, and the other thing here, going back to this drawing here, is if you've named beneficiaries properly on all your documents, like at your accounts at the bank or at the brokerage house or wherever, typically that will avoid probate. One of the things that we see as a question mark for a lot of folks is they typically have their spouse named, but they aren't sure about this second line, this contingent line. And so if that has been taken care of, like I said here, you can avoid probate, and it's very, straightforward and relatively simple. The key piece is the maintenance of that. So once you set it up, if you change, banks or you change financial institutions, that it's set up at the new place. And, that's where I just say, I call it dotting the I's and crossing the T's. It's just important. So, depending on what you're wanting or not, you can avoid probate with or without a trust. And even if you have a trust, you can still have a probate. We had a client who assured me that all of his mother's properties were in her trust, not drafted by us. And then she passed away and she had 3 pieces of real estate and 2 of them were not in her trust. So he ended up probating her will, even though she had a trust, because they hadn't done the proper integration over time. So,
and that's very common. That's very common. So that if you do end up with a trust, it's very, very, very important to accomplish your purposes, one of which may be, to avoid probate, to have the assets tied to the trust.
Yeah. That was a great question.
Yep.
So this question is kind of out of the main scope, I guess, but as a pastor, I am responsible for a church as well. Would that be something you folks could help with as well, to be able to roll that and figure out what to do with that?
So let me clarify what you're saying, Vincent. So are you saying like putting something inside the plan for who would step in and be the pastor if you passed away? Is that what you're saying?
In essence, yes. I think that gets the gist of it.
So, I mean, the short answer is I think that you could put whatever we needed to put in there. I think that there's a more long drawn out answer potentially based upon, how you guys do things in your congregation. Is there somebody already like kind of priming themselves as a successor to you? Or is there another church down the street that's affiliated with you that would be the pastor? And do other contracts and or things need to be put in writing outside of just even the estate plan?
Okay.
One of the big questions would be if there's a governing document currently in place that might speak to things like succession, and successor pastor or that kind of thing. So any existing document that might be in place that talks about these kinds of things would be relevant too.
Okay, but you are able to have that conversation. And you being
Well,
you and I.
Yeah, so when, for example, if you came in for a meeting and this was something that was a concern to you and we knew about it, we would say, hey, bring with you any governing document that you have for that church, whether it's like articles of incorporation. It may not have an actual corporate entity. It may, or it may have, some sort of membership agreement or something from a parent organization or something like that, that spoke to what happens, when you pass or become incapacitated. That existing document, if there is one, would be very, very relevant for us to look at as part of your whole plan.
Mm-hmm.
Okay,
Yeah.
very good.
Any other questions before we set you free on a Friday?
Was nice to meet you all virtually.
Yes. Thank you for
Thank you.
taking
Glad
an
that worked
hour
out.
out of your day.
Thank
Yeah.
you.
Thank you.
Thank you.
Stephanie, thank you for inviting us.
Well,
Yes,
thank
thank you,
you guys.
Stephanie.
Yeah,
I learned a lot.
good. Good, good.
Good.
Yeah.
All right.
Well,
Take care.
thank you, everybody. Have a great
Take care.
weekend, and
Bye.
we'll hope to see you all again here soon.